You do not want to make the mistakes I'm going to tell you in this video if you've been injured in a car accident. The 4 mistakes I'm going to go over in this video can completely destroy your case or significantly devalue it. To illustrate my points, let me tell you the story of my past client, Ava. Ava's case involved a car accident, but what I'm about to teach in this video will apply to any type of injury case, including not only automobile accidents, but also slip and trip and fall incidents, dog attack cases, and any other type of personal injury case. Ava was involved in a rear-end motor vehicle accident. The vehicle she occupied was rear-ended by a driver that was inattentive. After the accident, she did not go in an ambulance, but managed to get a ride to the hospital. Ava suffered injuries to her head, left hand, neck, left knee, shoulders, and low back. Diagnostic testing at the hospital did not reveal that Ava sustained any broken bones, but she was diagnosed with a concussion. The other driver's insurance company wanted to take Ava's recorded statement after her accident. And this leads me to the first mistake you want to avoid with the handling of your injury claim. It is a mistake if you give an adverse insurance company a recorded statement. You are not required to give an adverse party's insurance company a recorded statement. If you end up giving a recorded statement, your statement can be used later on in your case against you. The goal of the insurance company in trying to get you to give a recorded statement is to try to get you to say something that can be used against you to limit the amount the insurance company has to pay you. Thus, never give a recorded statement to an adverse insurance company. Now, back to Ava's case. After Ava was discharged from the hospital, she sought additional medical treatment, including physical therapy and pain management treatment. When it was all said and done, Ava's medical bills totaled a little under $27,000. I sent a demand package for Ava to the at-fault driver's insurance company, demanding that they pay out the insurance policy limits. In response to our demand, I got an initial offer of under $17,000 to settle Ava's case. However, I knew Ava's case was worth much more than that. And this leads me to my second mistake you want to avoid with the handling of your injury claim. It is a mistake if you accept the insurance company's lowball initial offer. An insurance company's initial offer is almost never the most amount of money they will be willing to offer you to settle your injury case, unless they are offering you the policy limits. You can negotiate a higher settlement. Oftentimes, you must show the insurance company you are willing to fight for a fair settlement. In Ava's case, I was dealing with one of the most, if not the most, difficult insurance companies. This insurance company is known for making claims difficult on injury victims. After Ava's lowball settlement offer came in, I wanted to show the insurance company that we were not going to just back down and accept a settlement for well below the value of the case. So I filed a lawsuit against the at-fault driver to show the insurance company we would not be backing down. And this leads me to the third mistake you want to avoid with the handling of your injury claim. It is a mistake if you fail to timely file a lawsuit after you get a lowball offer in your case. If you get a lowball settlement offer or an offer that is not fair, you should file a lawsuit. You see, by filing a lawsuit, insurance companies take your claim more seriously. It shows the insurance company you are not going to back down. Lawsuits can take a considerable amount of time and money to resolve. The insurance company will have to spend time and money defending your claim and hire a defense lawyer to defend the claim. By filing a lawsuit, you will almost always get a bigger settlement offer from the insurance in your case. But after filing the lawsuit for Ava, I was not done. I continued to litigate her case. With Ava's help, I answered written discovery questions on behalf of Ava that were sent over by the defense lawyer retained by the other driver's insurance company. I sent over written discovery questions to opposing counsel for the at-fault driver to answer. I produced Ava for her deposition. I communicated with the defense attorney via phone calls and several emails discussing the case. I also moved for a trial date, and we were ordered by the court to mediate the case. And this leads me to the fourth mistake you want to avoid with the handling of your injury claim. It is a mistake if you fail to work up your case after filing your lawsuit. If you file a lawsuit, you need to work up your case and prepare it for trial. Most injury cases do not end up going to trial, but working up the case and moving it towards a trial, you put pressure on the insurance company. If you fail to work up your case, the insurance company will not take your claim seriously. But if you do work up the case and push it towards a trial, it is much more likely an insurance company will raise the amount of money they are willing to offer you to settle your case. In Ava's case, we ultimately complied with the court's order and mediated the case a month prior to the trial date. Mediation is a settlement conference where a neutral party known as a mediator helps the parties try to reach a settlement in the case. We were able to settle Ava's case at mediation for nearly $90,000, which was well over 5 times the amount of the initial offer on Ava's case. If you want a fair and reasonable settlement in your injury case, it's not always going to come easy. The insurance company will not usually make it easy on you. You have to avoid the mistakes I discussed in this video if you want a chance at a fair and reasonable settlement like Ava got. The thing is, just because you avoided the mistakes in my video, it does not guarantee the insurance company will make you a settlement offer you believe to be fair and reasonable. And if you fail to get what you believe is a fair and reasonable settlement offer, you have to consider taking your case to trial. And in this video about to pop up here, I'll tell you what factors you should consider when debating to take your case to trial. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.